My name is Caleb Morrison. I'm 42 years old, a forensic accountant based in Phoenix, Arizona. For 14 years, I was married to Rachel Sterling, daughter of Victoria Sterling, CEO of Sterling Pharmaceuticals, a company that had dominated generic drug manufacturing across the Southwest for 3 decades. I always preferred precision over politics. Even with access to luxury through marriage, I valued accuracy over status. I was the invisible foundation supporting a pharmaceutical empire she inherited. Our marriage wasn't passionate, but it was stable, or so I thought. Rachel came from serious money, the kind that builds legacies on FDA approvals and patent portfolios. Her mother had transformed a small compounding pharmacy into a $200 million operation before Rachel turned 30. She inherited not just wealth, but the expectation to expand it. I fit into that world quietly, never demanding attention, never competing with her family's pharmaceutical shadow. I met Rachel at a medical industry conference in 2011. She was polished, confident, used to closing million-dollar licensing deals. I was there auditing insurance fraud cases, wearing a suit I'd bought at Men's Warehouse. We talked about numbers, about the difference between sustainable growth and creative accounting. She liked that I wasn't intimidated by her pharmaceutical pedigree. 6 months later, we were engaged. Her mother insisted on a prenuptial agreement. I signed without complaint. I wasn't marrying her for money. I was making decent money exposing fraudsters who thought they could hide behind complex financial structures. The years passed comfortably. We lived in a contemporary home in North Scottsdale with desert views and more square footage than 2 people needed. Rachel managed marketing strategy for Sterling Pharmaceuticals alongside her mother and the executive team. I worked forensic cases, insurance fraud, embezzlement investigations, the kind of financial detective work nobody notices until someone's stealing millions. Our lives ran parallel, intersecting at pharmaceutical industry events and family obligations. If you enjoy stories of calculated revenge and devastating legal reversals, you'll want to hear how this ends. Looking back, the warning signs were there. Over the last 2 years, Rachel grew distant. Marketing conferences became more frequent. Her mother's influence grew stronger in our household decisions. Rachel stopped asking about my cases, stopped laughing at my dry humor about corporate criminals, started sleeping in the guest room, claiming she needed better rest for early client calls. I noticed, but I didn't push. Maybe that was my mistake, or maybe it was my salvation. The patent lawsuit had been brewing for years. Before Rachel's grandfather died, Sterling Pharmaceuticals had filed a massive claim against Nexus Biotech, a rival firm that had allegedly stolen proprietary formulation data to win a lucrative generic insulin contract. The case dragged. Through discovery, depositions, expert testimony, it became background noise in our marriage. Rachel would mention it occasionally, always with frustration, never with hope. The pharmaceutical industry was cutthroat. Companies routinely accused each other of IP theft, and most cases settled quietly or disappeared into legal limbo. This one felt different, though. The evidence was substantial: internal emails, stolen research files, former employees willing to testify. Still, corporate litigation was unpredictable. Then, in late October 2025, the verdict came down: $9 million. The jury found Nexus Biotech guilty of trade secret theft, patent infringement, and intentional interference with business relations. The Phoenix Business Journal covered it. Local pharmaceutical industry blogs ran detailed analyses of the implications for generic drug competition. Rachel's phone didn't stop ringing for 3 days. Her family celebrated like they'd won the pharmaceutical lottery. I congratulated her that evening over dinner at our granite kitchen island. She smiled, kissed my forehead, and said, "This changes everything." I thought she meant the company's expansion plans, new R&D investments, maybe acquisition of smaller competitors, possibly international licensing deals. The pharmaceutical industry was consolidating, and $9 million could accelerate Sterling's growth significantly. I was wrong. 3 days after the money hit Sterling Pharmaceuticals' account, I came home from an insurance fraud investigation in Tempe to find an email in my inbox, sent at 11:47 p.m. Subject line: Important documents, time sensitive. The sender was listed as Sterling Legal Services. Inside was a PDF petition for dissolution of marriage filed that morning in Maricopa County Superior Court. I refreshed my phone, confused. Another notification. Our smart home system had been reset. All access codes changed, door locks reprogrammed. I was effectively locked out of my own house. Rachel walked out from the master bedroom, overnight bag in hand, car keys jingling. She was dressed for travel, business casual, the outfit she wore for pharmaceutical conference presentations. "I need to start fresh," she said, not making eye contact. "You're not part of that vision." No emotion, no apology, just a business decision delivered like she was terminating a vendor contract that no longer served the company's strategic objectives. She told me I had 48 hours to collect my belongings. Her attorney, Howard Pierce, the same man who'd handled her grandfather's patents and managed the family's pharmaceutical IP portfolio for decades, had already filed temporary orders granting her exclusive residence access. The prenup, she reminded me with clinical efficiency, was bulletproof. I had no claim to her inheritance, her business interests, or her litigation settlement. "The house, the accounts, everything stays with Sterling family assets," she said, checking her phone while talking. "Howard has prepared a fair separation agreement. You'll receive standard spousal transition support." Then she left. I heard her Tesla Model S pull out of the circular driveway, tires crunching on decorative gravel. I stood in that kitchen holding my phone, surrounded by furniture we'd chosen together during better years, in a house where I'd lived for over a decade. The pharmaceutical industry awards on the walls, the expensive wine collection, the imported Italian marble countertops, none of it had ever really been mine, and I felt nothing. Not anger, not sadness, just a cold, clarifying emptiness, like discovering a calculation error in a complex financial investigation. The kind that changes everything you thought you understood about the case. That night, I didn't call anyone, didn't drink, didn't break anything. I made coffee and started thinking. Because there was something Rachel didn't know, something her expensive attorney had overlooked in his rush to protect Sterling family assets. 6 years earlier, in spring 2019, Rachel's mother came to me with a problem. Sterling Pharmaceuticals had overcommitted on a clinical trial for a new diabetes medication. They had invested $800,000 in Phase 2 trials, but their research partner had pulled funding after preliminary results looked promising enough to threaten their own pipeline. The pharmaceutical industry was brutal that way. Companies would collaborate until the moment collaboration became competition. Then they'd withdraw funding and leave their partners stranded. It happened constantly, but Sterling had bet heavily on this particular compound. The diabetes market was worth billions, and generic alternatives were in high demand. Sterling needed $210,000 to bridge the gap until they could secure alternative backing from another research consortium. Without it, they'd have to abandon the trial, lose their investment, possibly miss FDA filing deadlines that would set them back years in the competitive diabetes medication space. Victoria Sterling sat across from me in our living room and laid out the situation with pharmaceutical precision. No sugarcoating, no emotional manipulation, just clinical analysis of their cash flow problem. The company was profitable but cash poor from aggressive R&D spending across multiple drug development programs. They had assets but no immediate liquidity for the diabetes trial completion. "I'm asking you as family," Victoria said, her voice carrying the same authority she used in boardroom presentations. "Not as a favor, as an investment. We need bridge financing and banks won't approve emergency funding fast enough to meet our FDA timeline requirements." I had the money. I'd been saving aggressively for years, living well below our means, while Rachel spent freely on pharmaceutical industry networking events, designer clothes for medical conferences, and luxury vacations that were supposedly business development opportunities. My salary as a senior forensic accountant was solid, $95,000 annually, and I'd been methodical about financial planning. I had $240,000 in various accounts: traditional IRA, Roth IRA, savings, and a small investment portfolio focused on boring index funds. I wasn't flashy with money, never had been. I preferred security over speculation, which is probably why I was good at forensic accounting. I understood that financial stability came from discipline, not luck. "What's the timeline?" I asked, already running calculations in my head. 8 months maximum, maybe 6 if the trial data is as promising as our preliminary results suggest. We'll pay prime plus 2 points, quarterly payments, full principal due at completion. Prime rate in 2019 was around 5.5%, so they were offering roughly 7.5% annual return. Better than my savings account, significantly less risky than pharmaceutical stocks, and it would help family business. It seemed reasonable. I thought about it for exactly 10 seconds. I'll do it, but I want proper documentation, not a handshake deal. Victoria smiled. She respected that approach. In the pharmaceutical industry, everything was documented, regulated, audited. Informal agreements were how companies got sued by the SEC or lost patent protection. Of course, Howard will prepare everything according to standard commercial lending practices. Howard Pierce, the Sterling family attorney who specialized in pharmaceutical law and intellectual property, prepared a loan agreement with standard terms. Clear repayment schedule, interest calculated quarterly, default provisions, and collateral specifications. But I had one additional request that seemed minor at the time, but would prove crucial years later. I wanted a clause stating that if the loan directly contributed to future intellectual property value, patent filings, or legal recoveries stemming from that specific research project, I would be entitled to proportional recognition as a contributing stakeholder in any financial benefits derived from the medication development. Howard looked at me over his reading glasses, the same way he probably examined patent applications for potential infringement issues. That's unusual for a family loan, Caleb. I'm not family, I said. I'm married to family. There's a legal difference, and we all know it. The pharmaceutical industry was full of stories about family members getting cut out of successful ventures because relationships soured or business priorities changed. I'd seen it happen during fraud investigations, family loans that became disputed assets during divorces or partnership dissolutions. Howard drafted the addendum with typical legal precision. 2 paragraphs, technical language that covered intellectual property rights, licensing revenues, litigation recoveries, and any other financial benefits stemming specifically from the diabetes medication research I was funding. It was buried in a supplemental document attached to the primary loan agreement, the kind of legal boilerplate that most people sign without reading carefully. Victoria signed it. Rachel signed it as a witness, barely glancing at the language. I signed it, understanding every word. The notary stamped it. I kept an authenticated copy in my personal safe deposit box at Chase Bank, separate from our joint accounts and Sterling family financial records. Sterling Pharmaceuticals repaid me in full 9 months later, June 2020. The clinical trial succeeded beyond their expectations. The diabetes medication received expedited FDA approval 6 months later. Sterling's stock price doubled. Victoria sent me a bottle of expensive scotch with a note thanking me for believing in their research vision. Everyone was happy. The paperwork went into filing cabinets somewhere in Howard's pharmaceutical law offices, and nobody thought about it again. Except me. I never forgot about it. I'm a forensic accountant. I remember every significant financial transaction, every contract detail, every potential future implication. It's how my mind works. The night Rachel served me with digital divorce papers, I couldn't sleep. I sat at my home office computer and started reviewing documents, bank statements, tax returns, pharmaceutical industry filings. I wanted to understand the full scope of what I was walking away from, not because I intended to fight for Sterling family money, but because I needed to see the complete financial picture. 14 years of marriage leaves complex financial entanglements, and I wanted to ensure I wasn't missing any obligations or opportunities. That's when I noticed something in the court filings for the Nexus Biotech lawsuit. I downloaded the public records out of curiosity, wanting to understand how Sterling had achieved such a decisive victory in pharmaceutical litigation. Most IP cases settled quietly or got buried in appeals for years. The case centered on stolen formulation data, but the damages calculation was more complex than I had initially understood. Sterling's legal team had argued for lost profits from several products, including future market projections based on their successful track record in generic drug development. One of those products was listed as diabetes medication portfolio, Sterling Protocol 7, the same medication I'd helped finance through clinical trials in 2019. The legal documents described it as a cornerstone of Sterling's research capabilities and market penetration strategy. The legal theory was sophisticated. Sterling's attorneys argued that Nexus Biotech's theft had delayed Sterling's ability to maximize market share in multiple therapeutic areas. They couldn't pursue aggressive expansion because they were defending against stolen intellectual property and dealing with unfair competition from their own research. The successful Protocol 7 medication was cited as evidence of Sterling's R&D capabilities, proof they could develop profitable generic alternatives in competitive markets. The profits from that medication, which had generated over $15 million in revenue since FDA approval, were used to calculate projected losses from contracts they couldn't pursue because of Nexus Biotech's interference. The pharmaceutical industry operates on complex financial models. When one company steals another's research, the damage isn't just direct competition. It's the opportunity cost of resources spent fighting litigation instead of developing new products. In other words, my loan had saved research that became a cornerstone of their $9 million victory. Without my bridge financing, Protocol 7 would never have reached market. Without Protocol 7's success, Sterling couldn't have proven their capacity for profitable drug development to the jury. I pulled out my copy of the loan agreement from my safe deposit box, read it 3 times with the careful attention I applied to insurance fraud investigations. The addendum was clear: proportional recognition as a contributing stakeholder in any financial benefits derived from legal recoveries stemming from that specific research. The settlement wasn't direct profit from Protocol 7, but it was legally connected. The medication's success had been weaponized in Sterling's courtroom strategy as evidence of damages. My financing had enabled research that became essential to their $9 million award. I could argue that I was entitled to a portion of that settlement. The next morning, I packed my belongings methodically. I didn't fight Rachel's lockout demand or send angry messages to Sterling family members. I didn't post dramatic social media updates or call mutual friends for sympathy. I simply collected my personal items, loaded them into my Ford Explorer, and checked into a Residence Inn on East Camelback. The pharmaceutical industry was small enough that dramatic divorces became gossip quickly. I wanted to handle this professionally, quietly, until I understood my legal options completely. Then I called an attorney. His name was Austin Caldwell, a solo practitioner who specialized in complex contract disputes involving pharmaceutical companies. I'd worked with him on insurance fraud cases where biotech firms had inflated clinical trial costs or manipulated research data to secure funding. Austin was methodical, detail-oriented, and had a reputation for winning cases against well-funded pharmaceutical defendants who thought small practice attorneys couldn't match their corporate legal teams. He understood the industry's financial complexity and wasn't intimidated by pharmaceutical money or influence. I laid out the situation in his office that afternoon, showed him the loan agreement, the addendum, and the court filings from the Nexus Biotech case. Austin read everything twice, making detailed notes on a yellow legal pad, occasionally asking clarifying questions about pharmaceutical industry practices. "This is legitimate," he finally said, leaning back in his chair. "It's complex, but it's legally sound. The question is whether a judge will interpret the settlement as a financial benefit derived from your research investment." "What are my chances?" I asked. Austin considered carefully. He wasn't the type to oversell prospects or make promises he couldn't keep. 60-40 in your favor, maybe 70-30 if we present the financial connection correctly. The pharmaceutical industry loves documentation, and your contract is thorough. He paused, studying my expression. But here's the reality, Caleb. You're going to war with a family that has pharmaceutical money and industry influence. They'll fight aggressively. They'll make this expensive and public. "I don't care," I said. "Why?" he asked. "You strike me as someone who avoids unnecessary drama. Why not just walk away clean with whatever the prenup provides?" I looked at him for a long moment, considering how to articulate something that felt more emotional than financial. Because she waited until she had the settlement money to divorce me, she calculated the timing, she planned the execution, and I refused to let someone treat 14 years of my life like a failed pharmaceutical trial they can just terminate when it's no longer profitable. Austin nodded, making another note. "Then let's file." We prepared a motion to intervene in the divorce proceedings, requesting judicial review of the marital estate to include my claim under the loan addendum. Austin drafted it with pharmaceutical precision, detailed financial analysis, clear legal precedents, expert documentation of the connection between my financing and Sterling's litigation success. We filed it on November 8, 2025, exactly 1 week after Rachel served me with digital divorce papers. The timing was deliberate. I wanted Sterling family to understand that I approach problems with the same methodical patience I used in forensic investigations. The response was immediate and predictably aggressive. Howard Pierce called Austin within hours of receiving the filing. He was furious, accused me of harassment, of trying to extort the Sterling family, of being a vindictive ex-husband, leveraging insider pharmaceutical knowledge for personal gain. Austin listened politely to the tirade, then said with professional calm, "File your response with the court. We'll see you at the hearing." Rachel tried a different approach. She sent me a handwritten letter delivered to my hotel room by courier service. 3 pages, single-spaced, full of words like mutual respect and dignified transition and moving forward positively for everyone involved. She reminded me of pharmaceutical industry events we'd attended together, successful Sterling family milestones I'd witnessed, the comfortable life we'd built in Scottsdale. She said she never wanted to hurt me, that the divorce timing was coincidental, that Howard had advised immediate action to protect company assets from potential complications. She offered to cover my relocation expenses, pay for 6 months of rent on a new apartment, and provide additional financial transition support beyond the prenup requirements. It was a generous offer, probably worth $50,000 or more. I didn't respond. I forwarded the letter to Austin for review. Victoria Sterling called me directly 2 days later, which surprised me. She'd always been professionally cordial, but emotionally distant, treating me like a peripheral family member who served a function but wasn't central to Sterling pharmaceutical operations. Now, her voice carried controlled anger beneath pharmaceutical politeness. "Caleb, this legal action is beneath you," she said. "You're better than this vindictive behavior." "Is it vindictive to enforce a contract your attorney prepared?" I asked. "You signed a prenup. You understood the arrangement from the beginning." "I did," I said. "And I also signed a loan agreement with an addendum that Howard Pierce drafted specifically to protect my investment. If you want to honor contracts selectively, that's your choice, but I prefer consistency." She hung up without another word. The preliminary hearing was scheduled for December 3rd. Austin filed a motion to freeze a portion of the settlement funds, pending resolution of my claim. We requested $1.2 million, enough to cover my potential recovery plus legal costs if we won. Judge Helen Vasquez, a no-nonsense woman with extensive experience in complex pharmaceutical litigation, granted a temporary hold on the requested amount. The order was entered into public record that afternoon. That freeze sent shockwaves through Sterling Pharmaceutical's corporate structure. Suddenly, money Rachel thought was entirely accessible for company expansion was partially frozen pending family legal drama. Business partners started asking questions about Sterling's internal financial management. Pharmaceutical investors wanted explanations about unexpected legal complications. The freeze also meant Sterling couldn't proceed with planned acquisitions or R&D investments that depended on settlement funds. Victoria had to explain to the board why family legal issues were affecting corporate strategic initiatives. Howard Pierce's reputation took an immediate hit. Word spread quickly through Phoenix's pharmaceutical legal community that Sterling's longtime family attorney had missed a critical contractual clause in a major financial transaction. Partners at other firms started questioning his oversight on their own pharmaceutical deals. The weeks leading up to the hearing were quiet on my end. I went to work every day investigating insurance fraud and embezzlement cases, the same methodical financial detective work I'd done for years. My colleagues knew about the divorce, but I didn't share details about the legal complications. When people asked how I was handling the situation, I said methodically and changed the subject. I've never been someone who processes emotions publicly. I deal with problems the way I deal with forensic investigations. Identify the discrepancy, calculate the evidence, execute systematically. Rachel, on the other hand, was unraveling according to pharmaceutical industry contacts. She'd stopped attending Sterling's marketing strategy meetings. Her mother had to take over client presentations and pharmaceutical conference appearances. One of her colleagues told someone, "I knew that Rachel wasn't herself," that she kept asking how I'd found the loan documents, as if I'd done something underhanded by keeping detailed records of my own financial transactions. The pharmaceutical industry runs on documentation and regulatory compliance. The idea that someone would be surprised by thorough record-keeping revealed how little Rachel understood about professional financial management outside the Sterling family bubble. Howard Pierce tried one final informal approach before the hearing. He invited Austin to lunch at a steakhouse in Old Town Scottsdale, suggesting we could settle this between gentlemen without dragging Sterling Pharmaceuticals through public legal proceedings. He offered me $250,000 cash, no strings attached, complete confidentiality agreement. I could walk away, start fresh anywhere I wanted, with no further claims against Sterling family assets or pharmaceutical business interests. Austin called me immediately after the lunch meeting. "They're scared," he said. "That offer tells me everything about their case assessment. They know we have legitimate grounds." "What did you tell him?" I asked. "I told him we'd see him in court." The hearing took place on a cold Tuesday morning, December 3rd, 2025. The Maricopa County Superior Court building, downtown, was busy with the usual mix of attorneys, defendants, and families navigating Arizona's legal system. I arrived 30 minutes early wearing a navy suit I'd bought specifically for this appearance. Austin met me outside the courtroom, reviewing last-minute details about our presentation strategy. "Remember," he said, "let me handle the legal arguments. If Judge Vasquez asks you direct questions, answer simply and honestly. Don't elaborate unnecessarily or show emotion." "I don't plan to," I said. Rachel arrived with her pharmaceutical legal entourage, Howard Pierce, another senior attorney from his firm, specializing in family law, Victoria Sterling, and Sterling's head of corporate legal affairs. They filled an entire bench on the opposite side of the courtroom. Rachel looked thinner than I remembered, her face drawn despite professional makeup. The stress was visible. When our eyes met briefly, she looked away immediately, focusing on papers Howard was reviewing. Judge Vasquez called the case. Austin stood and presented our argument with forensic precision, the same methodical approach I used in financial investigations. He walked through the timeline, the loan in 2019, the addendum clause, the diabetes medication research, its inclusion in the Nexus Biotech lawsuit as evidence of Sterling's damages. He submitted the authenticated loan agreement, court filings from the Nexus case, and financial records showing Protocol 7's market success and its role in Sterling's litigation strategy. "Your Honor," Austin said, "this isn't a case of a disgruntled spouse seeking revenge against pharmaceutical wealth. This is a straightforward contract dispute. Mr. Morrison provided capital that directly enabled research, which was later used as the foundation for a $9 million damage claim against Nexus Biotech. The addendum clearly states he's entitled to proportional recognition as a contributing stakeholder in legal recoveries stemming from that specific research. Sterling's settlement qualifies under that provision." Howard Pierce countered with the prenuptial agreement, arguing that I'd waived all claims to Rachel's separate property, including inheritances, business interests, and legal settlements. He characterized the loan as a gift between family members and dismissed the addendum as boilerplate language that was never intended to apply to unrelated pharmaceutical litigation. His argument was weak, and everyone in the courtroom could sense it. He kept returning to the prenup, as if repetition would make it more legally relevant, but prenuptial agreements don't override independent business contracts. Judge Vasquez listened without interruption, occasionally making notes. She asked Austin 3 specific questions about the addendum language and its enforceability under Arizona contract law. She asked Howard 2 questions about why the loan was documented as a formal business agreement rather than a gift, if it was meant to be informal family support. Howard's answers were vague and circular. He couldn't explain why Sterling Pharmaceuticals had insisted on proper documentation, quarterly interest payments, and collateral provisions for what he now claimed was a casual family favor. Then Judge Vasquez asked me directly, "Mr. Morrison, when you included this addendum in the loan agreement, what was your intent?" I stood, feeling completely calm despite the stakes. Your Honor, my intent was to protect my investment in pharmaceutical research. I wasn't giving money to family members. I was loaning capital to Sterling Pharmaceuticals for specific drug development. I wanted assurance that if that research succeeded and generated legal recoveries, I would be recognized for my financial contribution. That's standard practice in any business investment. She nodded. Thank you. You may be seated. The hearing lasted 2 hours. Judge Vasquez said she would issue a written ruling within 10 days. We filed out of the courtroom in silence. Rachel tried to approach me in the hallway, but Howard put a firm hand on her arm and steered her toward the elevators. I watched them leave. Victoria Sterling glared at me with pharmaceutical fury and complete disbelief that someone had outmaneuvered their family legal strategy. Austin and I went to a coffee shop around the corner from the courthouse. That went exceptionally well, he said. Judge Vasquez was clearly skeptical of their gift theory. She didn't buy Howard's argument about informal family arrangements. What happens if we win? I asked. Depends on how she calculates your proportional contribution. Best case, you get a significant percentage of the settlement based on your role in enabling the research. Worst case, you get your original loan amount plus interest and legal fees. But honestly, I don't think we're going to lose. The ruling came down on December 13th. I was at work investigating a healthcare fraud case involving inflated medical device costs when Austin called. I stepped outside into the Phoenix winter sunshine. We won, he said. Complete victory. Judge Vasquez ruled that the addendum is valid and enforceable under Arizona contract law. She calculated your contribution to the diabetes research as instrumental in enabling Sterling's litigation success. She awarded you 35% of the settlement amount, $3.15 million. I stood there holding the phone, looking out at the desert mountains in the distance. I didn't feel triumphant or vindictive. I felt vindicated, professionally and personally. Caleb, you still there? I'm here, I said. Thank you, Austin. They have 30 days to appeal, but I doubt they will. Judge Vasquez's ruling is comprehensive and well-reasoned. Congratulations. The fallout was immediate and devastating for everyone involved. The pharmaceutical legal community was small and word spread quickly. Howard Pierce had missed a critical contractual clause in a major financial transaction, and it had cost his client millions. His reputation took a massive hit. Partners at other pharmaceutical law firms started questioning his oversight on their cases. Within 3 months, industry contacts told me he'd been quietly forced into early retirement. Rachel's situation was worse. The ruling didn't just cost her money, it exposed her judgment to the Sterling family and pharmaceutical industry. Her family had trusted her to handle the divorce professionally and discreetly. Instead, she'd rushed into it without proper legal review. And now Sterling Pharmaceuticals was entangled in the public legal drama that affected their corporate operations. Victoria Sterling was furious. According to sources inside Sterling Pharmaceuticals, there were heated boardroom confrontations. Rachel was removed from key marketing decisions and client relationships. Other executives took over pharmaceutical accounts she'd managed for years. I received the settlement payment in late December 2025. $3.15 million minus legal fees and taxes left me with just over $2.3 million in liquid assets. I'd gone from having almost nothing in the divorce to being independently wealthy through pharmaceutical industry vindication. But the money wasn't the point. It never had been. What mattered was this. Rachel had tried to erase me from her successful life, to reduce 14 years of partnership to an inconvenient obstacle she could digitally delete once the pharmaceutical money was secure. And I had proven that you can't rewrite history just because it's no longer convenient. Actions have consequences, contracts have meaning, professional relationships have value, even when personal relationships end. I didn't celebrate or call old colleagues to brag. I simply transferred the money to new accounts, updated my financial planning, and started thinking about what came next. For 14 years, I'd lived someone else's life in someone else's pharmaceutical empire, under someone else's family expectations. Now, I had complete freedom to build something entirely my own. By February 2026, I'd left Phoenix for Flagstaff. Different mountains, different possibilities, different life, entirely mine. I established Morrison Forensic Solutions and discovered that professional vindication was more satisfying than any pharmaceutical fortune. Sitting in my Flagstaff office, Reviewing contracts for clients who respect expertise over inheritance, I finally understand which calculation created the better life.